everybody. I'm Gwendolyn Sterk of Sterk Family Law, and Terry Fogarty, one of our attorneys, is present here with us, and he does estate planning as well as guardianships here in Illinois. So thanks for joining me, Terry, today.
Oh, thank you, Gwen.
We're going to talk about types of guardianships because I think that there is a misconception in Illinois that if you have a guardian appointed because you're adjudicated as a disabled adult, that it has to be for every aspect of your life. And that's not necessarily true, is it?
No, not at all. There are actually two basic types of guardianship. There's a guardian of the person and a guardian of the estate.
Okay.
Guardianship of the person basically covers that person's care, can be their health care or just their general well-being. And then the guardian of the estate is actually handling basically their monetary issues for them.
Okay, so we have those two types of guardianships, but even in those instances, isn't it true that you can get a limited guardianship or a plenary guardianship?
It is. It's always the goal of a guardianship to maximize the individuality of the ward, which is the person for whom the guardianship is granted.
Okay.
So if a medical professional and the judge basically see that that person is capable of doing certain things, they will not grant what's called a plenary guardianship, which is a total guardianship over someone, but they can grant a limited guardianship, which gives the ward the ability to make certain decisions for themselves, but then gives the guardian the ability to make the tougher decisions.
And then a plenary guardian, on the other hand, would be the one that would make all the decisions in
Correct.
those areas, whether it be of the person, estate, or both, right? They could
Correct.
also be of both.
Yes.
So is it true that limited guardianships are not the norm in Illinois?
It is true, and that's because it can be very difficult for the judge to determine exactly what a ward can and can't do. But as I mentioned before, it really is their goal to maximize that individuality and maximize their ability to care for themselves.
Sure.
So it really should be taken into account. And the step where that really can be best taken into account is when a physician's report is drafted.
Okay.
If the physician can better outline what that ward can and can't do for themselves, it may be much easier to have that limited guardianship put into place.
Now, what if you needed a temporary guardianship? So there's something that's urgent that's come about, and you have somebody that really is disabled and not able to make that decision. Can you ask that court for that type of guardianship to be appointed?
You can. A lot of people call this an emergency guardianship, but really it's just a first step in the guardianship process. Basically, when you start a guardianship, it takes a little bit of time because you need to get a physician's report filed. You have to file the documents with the court, and that can take a little bit of time to gather all those things together.
Okay.
But if the ward or the potential alleged disabled person may not be able to take care of their affairs in the interim of that guardianship being granted and the date that you go in and file it, you can ask for what's called a temporary guardianship, where the court will give you 30 or 60-day guardianship, basically to ensure that that person is well taken care of.
Got it. Now, there's also been terms called like successor guardian. Where might that be appropriate?
So a successor guardian will be appropriate when either a guardian passes away and they're no longer available to take care of their ward,
Okay.
Or if a guardian decides that they just are unable to do it anymore or unwilling to do it anymore.
Sure.
A lot of times you'll see other family members become successor guardians. So, a sibling is taking care of mom or dad, and the other siblings steps up and says, "You've been doing this long enough. I think it's my turn."
And that successor guardian could ask for a termination of the prior guardian to come in, or it could be named through your will. Is that correct as well?
That's correct. You can name a successor guardian, or you can name a guardian in your will, so that person can become
The successor. Interesting. I think that this particular podcast is important to that parent that has that child with special needs, and they get to age 18 and they say, "I'm really concerned because they can't make financial decisions. They can't necessarily make good, sound medical decisions, but there's certain areas of their lives where I want to let them have the ability to see if they can make decisions for themselves." So understanding that limited guardianship might be an option at that age group, I think, is also important for parents to consider. Do you agree?
Yes, I agree. That's definitely very important, especially with somebody who may have a slight disability but really can function on their own. Because you really want to take that extra step, right?
Sure.
When your child turns 18, technically in the eyes of the legal system, they're an adult.
Right.
So this really is a way to help make sure that they're not taken advantage of and that they're well taken care of.
It's very good. So very important stuff. If you are a parent or you have an adult in your family that you think a guardianship is appropriate for, or if you're a ward, him or herself, you might want to get legal advice to find out how you might be able to terminate or limit a guardianship as well, correct?
Yes, that's correct.
So all these options are available. You can contact us at Sterk Family Law. Terry is available, can give you a free consultation on these issues, and I think it's important that we all learn more of the types of guardianship in Illinois. Thank you.
Yes, definitely. Thanks, Gwen.